I want to talk a little bit about the jurisdiction of the International Criminal Court. I guess I'm calling it authority here. I have a different conversation in a different place talking about when the International Criminal Court has jurisdiction over different crimes. But here I'd like to talk about the specific crimes that the court is able to oversee and prosecute. And so those include crimes against humanity, which are talked about and laid out in Article 7 of the Rome Statute. War crimes, which come from the Geneva Convention, particularly the grave breaches protocols of the Geneva conventions, and then also are articulated and connected in Statute 8 of the Article 8 of the Rome Statute. And then finally, the crime of aggression, which is also part of Article 8 in a separate section, but then also is linked to a UN General Assembly resolution that sort of lays out a definition of what constitutes aggression in terms of examples. And so I'm going to talk through some of these. If folks want, they can go and track down the documents. If they want, they can pause and look more carefully at some of the slides. But there's a lot of different components of this. And so if we're thinking about crimes against humanity, it runs the gamut from murder to enslavement to forced deportation to torture to sexual violence to targeting a particular group based on religion, culture, ethnicity, sex, enforced appearances, apartheid, or something similar. But there tends to be a standard in terms of when we'd say crimes against humanity have occurred, to note that it's not just a single incident, that oftentimes these crimes need to be widespread. So they're occurring in a way that is on such a scale that they must be known, they must be directed. Or we're talking about a systematic set of occurrences that are going after a civilian population, and importantly that we can demonstrate that they're done with the knowledge of the people who are being held accountable for these crimes. So there is the implication that you have to have a level of awareness to be charged with a crime against humanity. It can't be something that kind of occurred under your watch, but you weren't aware was happening. You didn't have the ability to direct. You weren't actively taking part in. In terms of war crimes, again, these are largely derived from the Geneva Convention, and I'll highlight something that I didn't talk about in my conversation on humanitarian law, which is that states set up two sets of rules. There's a set of rules that apply solely to international armed conflicts, right? Killing a surrendered combatant, misusing a flag of truce, settling occupied territory, poison weapons, civilians as shields, these kind of things, child soldiers, apply only when we're talking about wars between countries. States kind of carved out a number of exemptions for non-interstate conflicts, particularly thinking about a civil war or suppressing an insurgency. There are, however, crimes that apply in those situations, as well as in international conflict. So murder and torture fall under that, direct attacks on civilians, humanitarian aid workers, peacekeepers. It doesn't matter if that's occurring within the context of a civil war or in the context of an interstate war, it's still considered a grave breach and a war crime. And again, I think this reflects a lot of the I don't say the tension, because I use that word a lot, in humanitarian law, of states wanting to set these rules, but also not wanting to unduly constrain themselves, and yet recognizing that there are some actions that are beyond the pale, even when suppressing an organization, a rebel group that's trying to overthrow the state. Things like summary executions or taking hostages or sexual crimes are not permissible in any context, interstate or intrastate. And then finally, when we think about the crime of aggression, there's a definition that we're talking about the use of armed force by a state against the sovereignty, territorial integrity, or political independence of another state in a manner that's inconsistent with the UN Charter. And so the UN Charter allows for self-defense. It allows for military action to be taken when authorized by the Security Council. Folks would argue possibly under the Genocide Convention, you could take military action because the Genocide Convention obligates states to stop the crime of genocide. other humanitarian interventions may potentially be permissible, or at least not count under the crime of aggression. In terms of laying out sort of the variety of what this might look like, this is where the Rome Statute makes reference to a UN General Assembly resolution from the 1970s that talks about various different ways we can think about aggression, whether it's invasion of territory, whether it's bombardment or a blockade, is considered an act of aggression. It could be just simply attacking the military forces of another country, attacking their air force could be considered that. It could be situations where you are using troops within a country that were agreed upon for their stationment there against the state. It could be, assisting another state in launching an invasion by allowing them to base out of your territory, or it could be using mercenaries or irregular bands to attack another state. All of those would fall under the crime of aggression, and all of those would fall under crimes that the International Criminal Court conceivably could prosecute if it had the appropriate political jurisdiction over a particular state or over a particular situation. So again, very, very quick run through, but I wanted to kind of highlight those three different kinds of crimes that the International Criminal Court does pursue, and kind of give a sense of where those definitions come from in international law and how they might be different. Crimes against humanity focusing on things that are probably more associated with human rights violations, humanitarian law being the war crimes piece, and then the crime of aggression dealing with states' behavior toward each other.